Let's suppose that I'm appointed special counsel. With those words, Senator John Kennedy began what can only be described as a masterclass in constitutional law, delivered live on the floor of the United States Senate. His target, the Attorney General; his subject, the extraordinary and legally treacherous process of obtaining the private phone records of a sitting United States senator. This wasn't just a series of questions. It was a methodical, sarcastic, and brilliant deconstruction of a political bombshell. Today, we're going to walk you through Senator Kennedy's legal lesson, step by step. This exchange didn't happen in a vacuum. It came just days after a group of Republican senators held a press conference accusing the Biden FBI of secretly obtaining their phone records. The accusation of political weaponization hung heavy in the air. Senator Kennedy's goal in this hearing was not to simply repeat those accusations, but to dissect the legal mechanics of how such an act could even be possible. He put the Attorney General in the witness chair, not just as a cabinet member, but as a student in his impromptu class on the rule of law. The lesson began with a simple, hypothetical premise.
General, welcome. Let's suppose that I'm appointed special counsel at the Department of Justice, and I go to the telecommunication companies, the phone companies. Let's single out AT&T, and I say, look, I know you're busy, but I want to see a copy of the phone records of a sitting United States senator. They're not going to just give them to me, are they?
No, Senator, of course not.
In fact, they're probably going to ask me what planet I just parachuted in from, aren't they?
Yes, Senator.
They're going to tell me to come back with a subpoena, aren't they?
Yes, Senator.
Okay. What do I have to show in that subpoena to get those phone records of a sitting? Did I mention it was a sitting United States senator? I can't remember. What do I have to show to get the phone records of a sitting United States senator?
Yes, Senator, there were actually 8 sitting United States
Yeah, I
senator,
heard that.
and you would have to have cause.
I'm sorry, what do I have to show?
You would have to have cause to get the
Good
subpoena.
cause or probable cause?
Probable cause.
Okay. Probable cause, or if it's a subpoena, duces, tecum, good cause, to show what?
You would need good cause for a subpoena duces tecum, and what you would have to show is that you believed a crime had been committed, or there was a possibility of a crime, or that could lead to other crimes. We frequently, in criminal enterprises, subpoena cell
by
phones.
the sitting United States senator.
Senator, they would have to have believed you were part of a criminal conspiracy, is my understanding.
Would a judge have to sign off on it? On the subpoena?
Yes, Senator.
Having established the high legal bar of probable cause, Kennedy then moved to his next exhibit, the role and responsibility of the phone companies themselves.
Now, the phone companies, particularly their general counsel, if they're worried about civil liability, even with a subpoena to get the phone records of a sitting United States senator. Did I mention it was a sitting United States senator?
Yes, Senator.
The general counsel for that phone company, let's say AT&T, they have the right to seek to quash that subpoena, don't they?
Phone companies frequently do that.
Yeah. And a smart general counsel for that phone company is going to call the sitting United States senator and say, would you like to weigh in on this? Would you like me to quash the subpoena? We're talking about invading someone's privacy here by a sitting United States senator. Could the general counsel for the phone company do that?
Well, Senator, if they believe that a crime could have been committed, they could not tip off the person who committed the crime Again, I can't comment on details of this
Yeah, I'm not
particular
asking,
case.
I'm just asking you theoretically.
I've never seen you commit a crime, Senator
But
Kennedy.
let's suppose, okay, they didn't want to tip off the sitting United States senator. But the phone company and the general counsel for the phone company, or companies, if there were more than one involved, could say, you know, this is serious as an aneurysm. This is serious as 4 heart attacks and a stroke. This is a sitting United States senator. So general counsel would likely advise the CEO, well, you need to file a motion to quash. The telephone companies could have contested those subpoenas, could they not?
Hypothetically, yes, I can't talk about the facts of this particular
We're
case.
talking hypothetical.
Senator, subpoenas are issued all the time through phone companies working with the general counsel.
But they can file
for
a motion to
cause.
quash.
They could, yes.
And then, after laying the legal groundwork, Senator Kennedy delivered the sarcastic punchline that summarized his entire argument about corporate cowardice.
Or maybe they should have gone to Amazon and buy some testicles online. Instead of just saying, sure, I'll just show you the phone records of a sitting United States senator on the basis of an administrative subpoena.
What Senator Kennedy did here was brilliant. Instead of making a fiery political speech, he used the Socratic method, forcing the Attorney General and the audience to walk through the legal process with him. He explained complex legal concepts like probable cause and motion to quash in a way anyone can understand. His argument is subtle but devastating. If the FBI's investigation was legitimate and followed procedure, it should have triggered a massive public legal fight from the phone companies, who would be terrified of the civil liability of handing over a senator's records without a fight. The fact that this didn't happen, he implies, means one of two things. Either the FBI used a method that bypassed proper legal channels, or the phone companies showed a shocking level of cowardice. His final crude remark about buying testicles on Amazon was designed to be a viral soundbite that underscores this point. This was more than just political theater. It was a public lesson on the separation of powers and the checks and balances designed to prevent the abuse of investigative power. Senator Kennedy's hypothetical exercise leaves us with a real and troubling question. In the rush to investigate, were legal guardrails ignored? And are the corporations that hold our most private data willing to protect it? Especially when the government comes knocking. Let us know what you think of Senator Kennedy's unique style of questioning.